Hello and welcome, everyone. Good morning. Welcome to the Understanding Education Civil Rights Issues Resulting from COVID-19. My name is John Hawkins, and I'll be your moderator for this session. Just a few housekeeping rules. Before we get started, remember if you have any questions, please type in the chat box. We will definitely try to get to as many of those questions as possible by the end of the session. Also in the chat box, we will have a survey available to you during the Q&A portion of today's presentation. So also just an early reminder, if you are planning to attain your professional development or your continued education credits, you have to fill out the survey, is what I was instructed to tell you all. So please complete those by the end of the session. Your answers also help plans for next year's conference, so it's really important. Toward the end of the session, we will provide a link in the chat box. That link will connect you to the survey. So without further ado, everyone, please welcome Tim Schultz. I'm gonna read a little bit about Tim before he begins his presentation. Tim Schultz currently serves as Deputy Director and General Counsel of the Indiana Civil Rights Commission, ICRC. The agency charged with enforcing the Indiana civil rights laws and provides education and services to the public in an effort to ensure equal opportunity for all Hoosiers. Immediately prior to joining ICRC, Mr. Schultz served as the General Counsel for the Indiana State Board of Education. Over the course of more than 4 years with the board, Mr. Schultz provided counsel to the board members on a variety of topics, including school accreditation, assessment, and academic accountability issues, grant programs, and virtual education. In his capacity as General Counsel for the board, Mr. Schultz also had the opportunity to work with policymakers to assist in the development of education initiatives and future goals. In his current role, Mr. Schultz oversees the agency's complaint intake, investigations, alternative dispute resolution, and litigation divisions, as well as coordinating agency efforts with the Department of Housing and Urban Development and the Equal Employment Opportunity Commission. In this capacity, Mr. Schultz works to ensure all Hoosiers have an equal opportunity to education, employment, access to public accommodation, fair housing in accordance with the state's civil rights laws. So without further ado, I welcome Tim Schultz, who will be your presenter for this morning's session.
Thank you, John. I just want to say I'm very excited and honored to be part of this discussion today. This is obviously, we're living in a very interesting time right now as far as education issues relating to the public health crisis. And I really hope that the information I provide today offers some insight and leads to some further discussion to make sure that we are doing everything we can to make sure that our students continue to see or receive equal opportunities for education, but also in a safe manner. So with that, I will go ahead and begin my presentation. So as John mentioned, the title of this course today is Understanding Education Civil Rights Issues Resulting from COVID-19. My name is Tim Schultz. I'm the Deputy Director and General Counsel for the Civil Rights Commission. Before we begin, I just wanted to provide several disclaimers. ICRC, we don't make the laws, we simply enforce them. Nothing discussed today is intended to be legal advice. For legal advice, you're encouraged to contact an attorney. And this presentation is intended to provide general information and guidelines, and it's not considered official Indiana Civil Rights Commission policy. So just an overview of what we'll be discussing today. I plan to provide a brief ICRC, or a summary of the ICRC mission and jurisdiction, provide some background as far as what is unlawful education discrimination, transitioning to some of those unique education discrimination issues that we are seeing now due to COVID-19, and then wrapping up with some food for thought, just some best practices, and of course the Q&A session that John mentioned. So the Civil Rights Commission enforces Indiana Civil Rights Code and the Indiana Fair Housing Act. Our jurisdiction extends to individuals, private or public entities, housing providers, and business establishments within the state. The Indiana Civil Rights Commission's mission is the neutral investigation of complaints with the goal of eliminating discrimination against protected classes in the enforcement areas designated by Indiana law. And I want to stop for a moment and emphasize that word neutral. The Indiana Civil Rights Commission investigations are conducted in a neutral manner, which means we don't represent one side or the other. We are here to enforce the civil rights laws and develop those investigations by obtaining all of the relevant facts and making our decisions in that manner. And some people might ask the question, well, what is a civil right? Well, a civil right is an enforceable right or privilege, which is, if interfered with by another party, may give rise to an action for injury. In short, civil rights protect you from discrimination. So this next slide identifies the protected classes that are recognized in Indiana, as well as the enforcement areas that the ICRC oversees. And those protected classes include race, religion, color, sex, disability, national origin, ancestry, familial status, veteran status, and age. And our primary areas, or our areas of enforcement, are housing, employment, public accommodations, education, of course, and credit. And just some background, the areas of enforcement that the agency receives, the vast number of our official complaints are in employment and housing. So ensuring that people are being protected from employment discrimination and discrimination in housing, those make up the vast majority of our cases. But of course, we do receive education cases as well. So a little bit of background as far as what happens here at the ICRC when we get a complaint. So when an individual believes that they had a civil right, received a discriminatory practice impacting one of their civil rights, they can contact our agency either through phone or email or in person, at least when we start to take appointments again. And that individual will talk to our intake division. Our intake specialists will walk that person through the facts that are relevant for developing a sufficient complaint that can be investigated by the agency. And once an individual has had a chance to talk to one of our intake specialists, that matter, if it goes to a formal complaint, then goes to the investigation stage. And again, that's done in-house here at the agency. Our investigators will conduct multiple interviews with the complainant, the respondent, any witnesses, but also may subpoena documents as part of that investigation and engage in other discovery techniques, all aimed at, again, that neutral investigation, but making sure that all the facts are obtained during the course of that investigation. The result of that investigation may result in either a no cause finding or a cause finding. If there's no cause, that means that the investigation determined that there was not a violation of a civil right and that the matter will be concluded. Now, of course, the complainant has the opportunity to appeal that preliminary decision directly to our commission members who are the ultimate authority in such matters. Alternatively, an investigation may result in a cause finding in which they determine that there does in fact appear to have been a violation, and that matter then goes onto our commission through administrative hearing process. And that administrative hearing process is conducted by, again, our in-house counsel, staff attorneys, who will engage the matter and argue the matter in front of an administrative law judge, who will then issue a preliminary decision, which again goes to our commission for the final decision. That decision can then go up to the state courts for judicial review. And again, our staff will continue to manage that litigation. So we remain involved really from the beginning of the complaint to the end. And I think it's really important to note that, because we don't just take a complaint a certain way and then we're done with it. We take it from beginning to end. And I think it's also important to note that we aggressively pursue a settlement in these matters, because oftentimes that can resolve the matter much faster and the parties can also receive any potential damages that the parties agree to, but it can resolve the matter much faster. It can also result in updated policies for a respondent who might have a policy that was considered to be discriminatory in some way, and that entity might engage in training for its staff if it's a business, or an updated policy. And then one last thing I think it's worth noting, just kind of a little quirk that our agency deals with, that whole administrative hearing process that I identified can actually be bypassed, and you can go directly to state court. So it's always very interesting here, as far as you have multiple avenues to pursue your rights. So now that I've provided a little bit of background regarding what the agency, what our authority is, what's a protected class here in Indiana, and of course how things work once a complaint is received, I want to transition into what is unlawful discrimination. Well, unlawful discrimination is the prejudicial treatment of an individual based on their membership in a protected group or category. In short, treating someone differently or unfairly because of their protected class is likely unlawful discrimination. And that might seem obvious, but from a legal standpoint, discriminating between individuals is normally, quite often, is lawful unless it's prohibited by law. So for example, an employer may discriminate between applicants because the level of education or work experience multiple candidates might have. Or in respect to housing, a landlord may discriminate against applicants on the basis of their creditworthiness or ability to pay for a rental unit. Someone selling their home might prefer a cash buyer versus other potential buyers. But obviously, if that discrimination occurs based on the protected class, then there's a potential civil rights concern, and we would encourage somebody to contact our office in that situation. So, as I'm sure many of you know, in 1954, the Brown v. Board of Education decision was issued by the United States Supreme Court, holding that segregation of students in public schools on the basis of race deprives students of the minority group of equal education opportunities, and is a violation of their constitutional rights. And the way I look at it, and I think that the court noted this during that decision, that it's doubtful that any child may reasonably be expected to succeed in life if he or she is denied the opportunity of an education. Obviously education is just an incredibly important element of every child's life. So subsequent to that decision, you saw numerous federal and state statutes were enacted. And here in Indiana, our statute dealing with education is Indiana Code 22-9-1-2, which states in relevant part that, quote, "It is the public policy of the state to provide all of its citizens equal opportunity for education, and to eliminate segregation or separation based solely on race, religion, color, sex, disability, national origin, or ancestry." So before I continue and start to discuss a little bit about what the types of discrimination are that you might see or encounter in an education environment, I just want to take a moment and note that while Indiana has the code site that I just referenced, there are multiple federal requirements out there that either directly or indirectly deal with education discrimination issues. And here's a list of that's not even everything, but that's some of the main federal laws that deal with preventing discrimination in either in public education, K-12 education, but also higher ed situations. And of course it's expanded to all organizations that are receiving federal funds. So, as I noted, it's the state policy to provide all of its citizens with equal opportunity for education. Well, what does that mean? Well, it means that the right to an education free from illegal discrimination. In other words, it's against the law to be denied access or to receive a lesser education because of your protected class. And okay, so next question is, who can commit illegal discrimination? And the answer is a lot of parties. The actions of a student, a teacher, administrator, or other school employee may be discriminatory, but a school's policy and how it's applied can also be discriminatory. Moreover, the victim isn't necessarily one individual. It can be multiple people or an entire class of individuals. So the takeaway is that this protection, the civil right to equal education is expansive, and obviously it can be impacted in numerous ways by numerous parties. So the two types of unlawful discrimination that I really want to focus on today, and I think that are particularly relevant now in the world of COVID-19, are disparate treatment and disparate impact discrimination. So disparate treatment is when a person treats a person in a protected class differently than others not in that class. So basically, intentionally treating somebody differently is disparate treatment. Disparate impact is a little bit different, where you can have a facially neutral policy or practice not intended to discriminate, but has an unjustified adverse or disparate impact on students based on their protected class. So, that's where you might have a very well-intentioned policy, but ultimately the way it's impacting a protected class has a disproportionate impact. So digging a little bit deeper into it, because these are just very, very important concepts that I want to make sure people have an understanding of. So looking at disparate treatment, the questions that if we were to receive a claim or a complaint, the questions that we might ask when reviewing that complaint is, did the school district treat a student or a group of students differently with respect to providing access to educational resources as compared to another similar situated student or group of students? That's the first question. But then the investigation has to turn to the next part. Can the school district articulate a legitimate, non-discriminatory educational reason for the different treatment? If not, then that certainly would likely support a conclusion that there has been a disparate treatment discrimination. However, if the school can articulate a non-discriminatory reason, then the investigation has to dig a little bit deeper and determine if the reason offered by the school or individual is merely a pretext for discrimination. So in other words, not the true reason for the different treatment, but rather a mere cover for discrimination. Obviously, if that determination is made, then that would lead to a likely disparate treatment conclusion. Some examples where a reason offered by a reason for that discriminatory treatment by a school corporation could be contradicted by the fact that that policy contradicts the school corporation's policy. So it's the school doing its own unique thing that doesn't comport with the overall policies implemented by the school corporation. Or if the evidence simply just contradicts the explanation that's being offered. So that brings us to disparate impact. And disparate impact can be a much more complex investigation because, as I noted, it's the policy itself is neutral and unlikely to have any kind of discriminatory intent. It's the results that is discriminatory. So the question that we have to look at here is whether or not the policy is resulting in adverse impacts or having an adverse impact on a protected class of students when compared to other students. The investigation would then turn to whether or not that policy is necessary to meet an important educational goal. Whatever the school might offer to explain that, if there is a necessary goal, then the question then becomes: are there comparatively effective alternative policies or practices that might have less of an impact on those protected classes? Now, some educational policies that are put forth to that may result in disparate impact, are targeting school resources to underperforming schools. Obviously, you're directing resources in a non consistent manner, but there is an educational policy behind that. There is a school that has an underperforming population, and the decisions being made not based on any protected class, even though protected classes might benefit or be discriminated by that decision. But that would be an example of a reason why a school might engage in that kind of disparate impact conduct. So I know I've just thrown a lot out there, and so I figure a couple of maybe simple examples regarding disparate treatment and disparate impact would be helpful to kind of summarize the information I just explained. So in example one here, we have Acme School has a policy that will not accept students that have a disability. Well, here, this is clearly a discrimination problem because the policy directly implicates people with disabilities, which is of course a protected class. And this would be an example of disparate treatment because it's directly prohibiting protected class from attending a school. The second example, Acme School has a policy that will only admit students that achieve a certain score on standardized tests. Okay, well, this seems to be a facially neutral policy because it's not directed at any protected class and would apply equally to everyone. Persons in their protected classes may or may not achieve the desired test score. However, the result of this policy is what you need to focus on. Because if the result of the policy is that people in a protected class are being denied at a disproportional rate, then the impact, the result of that neutral policy is a disparate impact, and you potentially have a discrimination issue and a civil rights issue that could be pursued through our office. So turning now to, I've kind of summarized the types of discrimination that are most likely to come up right now with the current health crisis. I've explained a little bit about what the agency does and what is unlawful discrimination, and of course the areas of enforcement that we have here and the protected classes that can file a complaint with our agency. So let's turn to COVID-19. And despite the continuing public health concerns resulting from COVID-19, students in protected classes are still entitled to equal educational opportunities in a safe environment. And I just want to say that again. While we're certainly dealing with a health crisis, but that does not change the fact that individuals still maintain their civil rights. But again, as I noted, in a safe environment. So what does that mean? Well, that means that when schools are developing health policies and recommendations and implementing those policies, you still cannot either directly or indirectly discriminate against students. And those students are still entitled to that equal opportunity for education. So when you're developing those procedures, those health policies, it's very, very important that those policies are not based on, or that they are based on the actual risk. Without reliance on assumptions, stereotypes, or being applied in an inconsistent application. So what does that mean? What does it mean to base a health policy on a stereotype or an assumption? Well, let's take student screening as an example. So as schools start to reopen, you may have policies put in place where when students are, before they can, actually physically return, they're being asked questions about travel or, their travel, family member travel, things like that. However, if you're screening those students based on assumptions or stereotypes, then you're likely to create a civil rights issue. And so an example would be, schools are only asking students of Asian descent or with that are known to have family members in China, for example, if they've been traveling recently. Well, that type of screening is likely to be based on an assumption or a stereotype about that student's background, their national origin or ancestry, and such practices are likely to create civil rights issues because you're it's all being based on not the actual risk, it's being based on assumptions. Another area where you might start to see some issues start to develop is inconsistent testing. And this is similar to the screening concern that I mentioned earlier, but this could be done in a facially neutral way, but that could still have a discriminatory impact. So for example, let's just take a school corporation that's decided to have a policy that if any particular district or region within that school corporation has a certain number of positive COVID-19 tests that are reported, then any students coming from that district or that region of the school corporation are required to take a COVID-19 test before they can return to school. Okay, that seems like a facially neutral idea that you're using the science that you see that there's an actual number of increased positive cases in this area, so it's prudent to test students from that area. Well, the problem you might incur there is that that particular region might have a disproportionate number of students in protected classes from that region. So the impact, the result of that policy is that protected class of students are being disproportionately affected by the policy. And, but that's a great example, I think, of just like a good idea or a well-intended idea that ends up just resulting in, a civil rights issue. So staying with that theme of well-intentioned policies that might still create issues for you. So I think it's important that school administrators and officials be very mindful of the unintended consequences of data requests related to health and safety policies that they might put into place right now. So I think a good example is, the kind of information that you might start asking students before they come back into schools, as far as, their travel, but also, family status and questions about that might impact or at least be perceived from the student's perspective as relating to the student's, status as a citizen or immigration status. And not saying that that's the intention of the policy, but it's about perception. And if students start to have that perception that these data requests are related to that, it can have a chilling effect on the enrollment of those students in a school corporation. And that's obviously that can create an issue, and because if you have these students in a protected class, national origin, ancestry, those are protected classes here in Indiana that are being impacted by that policy. You can of course have a situation develop that might create a civil rights issue. And I think there's there's a good tip that schools could employ in a situation like that, where when you're implementing these types of policies, any of these policies that schools might be developing right now, continuous review. And what I mean by that, so in the example I gave, reviewing your enrollment data on a regular basis. If you start to see drops in enrollment for any protected class or group of students that you can't explain, well, then that might mean that you've got a policy that's having a disparate impact on that group of students, unintentionally so. But in order to make sure that problem is identified early, that's just having that regular review of what's happening and how the policy is being implemented can hopefully avoid any kind of civil rights violation. So that brings us to the next item, providing distance learning assistance, school meals, or other educational resources while imposing facially neutral policies or access policies for the access to those resources, which of course is a very hot topic right now. Distance learning obviously is happening nationwide. Schools have been making sure we're doing amazing work, making sure that students are still receiving any meals that they might normally receive in a school environment. and just also providing other resources. Well, what if schools may, I'm sure it's probably happening. Schools are imposing certain policies that are connected to those resources. So, for example, having a required identification, state identification, form of state identification when receiving meals from the school, for example. A school, let's say the school is taking those meals out to various distribution points, and a requirement for the pickup is that you have to have a state issued license. So while that might be facially neutral because you're simply trying to make sure that the right people are receiving the meal, that could, if that starts to have a disparate impact or a disproportionate impact on a protected group of students, then you're going to potentially have a civil rights issue going on. Same thing with, having some sort of like requiring that individuals prove that they have internet access before a school provides them with a Chromebook or a laptop for use with, for distance learning. Well, sure, if you just initially look at it, that makes sense. You want to make sure that if you're offering a resource like a computer to a student, that the student will be able to use it. However, if that requirement has a disproportionate impact on a protected class of students, again, you've got a civil rights issue. And I think that kind of goes back to what I was saying before about having some method to make sure that you're reviewing your policies to make sure they're working right, or just thinking ahead in a situation like that. Rather than requiring proof of internet access, having distance learning or developing your distance learning so that you can track student participation. So that eliminates the need for a student or a student's family to prove they have internet access. It also might have a positive result because if you're tracking student participation, you're also going to know if that student's falling behind or not participating. But it's an example of a policy that has less of an impact on any protected class compared to requiring that proof on the front end. So it's just one of those things that as we move forward with the current state of education in the world where COVID-19 is creating these issues, it's just about thinking about these policies that you're putting in place to make sure our students are safe, but also thinking the next step ahead. Is that policy going to impact or have a disparate impact on a protected class of students, unintentionally so? Another issue that comes up a lot is a question about students with disabilities. Are they, still, entitled to the same level of education access that they have when they're, physically in a building? And, short answer is yes. School districts must continue to provide equal opportunities for education to students with disabilities. Then that can lead to another question where are we talking about whether or not the student's receiving educational services or non-discriminatory access to equal opportunity for education? And there might be people out there right now who are like, well, what's the difference? And the difference is if you're talking about whether or not the student's receiving their appropriate education services, a student with disabilities, you're probably talking about a situation about whether dealing with a student's individual education program or a 504 plan. And if that's the situation where there's questions about the student's IEP or 504 plan, though there is a number of policies, regulations, laws that are enforced by the state's state education agency and Department of Education, Board of Education, and they have a whole series of policies for governing those kinds of concerns. However, a few years ago, the U.S. Supreme Court in Fry v. Napoleon School Corporation noted that there is a difference between these concepts of your educational services pursuant to your IEP or 504, and equal access to that education environment. And in that case, because when you're dealing with IEP issues, there's an administrative exhaustion element that has to be exhausted before a student can continue to pursue a judicial review and enforcement of whatever that student or student's family might be pursuing. In that case, the court noted that the student was actually pursuing it was an ADA claim about access to the school. If I recall correctly, it was dealing with a service animal being allowed in the school. And so it wasn't really a question of these are the educational services the student needs to learn. It was about access to the building, like physically being able to get to the building and move around the school building. And the reason why I'm offering this or going into some detail here is because the second part, that access to a building, could be considered a civil right. One, if you can't access the building, it's hard to say that you have equal opportunity for education, but also there could be a public accommodation issue there. And again, that's something that the Civil Rights Commission does have authority to review and investigate. Whereas if we're dealing with an IEP or 504 plan, it's likely that responsibility for reviewing the matter would fall to another entity and not be the Civil Rights Commission. But I think it's just important to note that the requirements for equal access to education or equal opportunity for education they're all still in place. I mean, even though we're dealing with COVID-19 and all the unique issues that creates, these civil rights remain in place, and it's up to schools and educators to find creative ways to make sure that those are in fact those civil rights are being delivered, and that people are able to enjoy their education in a non-discriminatory way. So I've kind of summarized a lot of the main issues that could come up right now in our current environment. So some food for thought, and really just reiterating some of the points that I've noted along the way here. Documentation. It never is a bad thing to document what you're doing, what is happening, in your school environment, your education environment, and having that information, can be key for if you do find yourself in a situation where an investigation by either our agency or any other number of agencies that deal with education matters, having that documentation is probably always going to be best for you. Reviewing and revising your policies and procedures on a regular basis. That goes back to that topic or that issue where I was saying that, certain kinds of data requests can have a chilling effect, possibly have a chilling effect on your student population. So, you don't just create a policy, put it in place and walk away. You got to make sure that you're checking on that and seeing what the impact of that policy is, because if you start to if it does have an impact on the students, even though it's a facially neutral policy, you could have a civil rights issue for that student. Obviously nobody wants that. And reviewing your policies on a regular basis can help prevent that kind of thing from coming up. Evaluate before you implement. Just your first idea might not be the best idea. So, going back to like the inconsistent testing policy I mentioned, where you think, well, we'll limit our testing for COVID-19 only to students who are in an area where we know there's an outbreak of positive tests. Well, okay, but again, if that area or if the area that ends up having that kind of hotspot is, has a disproportionate impact on a protected class of students, you're going to have a problem. And then, that kind of just to wrap it up, consistent implementation of all policies, not making assumptions, not making policy assumptions or decisions based on stereotypes or, screening students who have a certain background. That's the kind of thing, obviously, if you're not being consistent, you're just creating the possibility that you're going to have a problem down the road. And at the end of the day, it's all about making sure that all students have equal opportunity for education here in Indiana. I mean, that's the goal. And hopefully, some of this information that I've gone through and these policies and concerns have given you some food for thought. And as you start to develop these policies or continue to develop these policies to ensure our students are able to have that equal opportunity, but also done in a safe manner. So with that, I think we can begin the question, comment, and concern phase of this.
Yeah, thank you, Tim. We appreciate you presenting on the topic. We do have a few questions for you. So we're going to start with the first one. Do schools need to provide distant learning resources to all students in order to provide an equal opportunity for education or protected classes of students? And this was from Dave.
I apologize, John. You broke up for just a little bit there. Can you repeat that?
Sure. Can you hear me now?
Yes.
Okay. Do schools need to provide distant learning resources to all students in order to provide an equal opportunity for education for protected classes of students?
So that's an excellent question, and it's difficult to provide a simple answer. Really, as with many civil rights matters, it really depends on the facts. I think the main thing I would stress is that that generally speaking, schools have a lot of flexibility in how they provide education services, and when providing these distance learning services and resources to students, you need to be consistent. Going back to what I was saying, food for thought, analyze your programs, review your policies on a regular basis, and implement them in a consistent manner. And even when you think you're doing that, the impact, might be disparate and might disproportionately impact a protected class of students, which is why that review and follow-up part of it is so important.
Thank you for that, Tim. The next question is, can ICRC investigate possible education discriminations in a private school?
Oh, that's another great question. So I think the answer is probably yes. As always, it depends. But there was a decision from an Indiana court about 6 years ago where this issue came up in that there was I believe it was a race discrimination claim. The protected class was race, and the issue was, of course, education discrimination. And the individual attended I believe it was a private parochial school. And ultimately, the court determined that based on the language of the Indiana statute, the agency did have authority to research that. And it was interesting because the court also, noted that if this had been an employment discrimination claim, the result may have been different because the Indiana statute specifically allows for that education or equal opportunity for education is a civil right that, of course, the agency can investigate, whereas the language regarding employment discrimination is a little bit different. So I think the answer is yes, and based off of Indiana case law.
Thank you for that, Tim. Just a sidebar, everyone. The link for the survey is active. Again, if you do plan to receive any professional development credits or any continued education credits for any of these sessions, you have to, Court IB, you have to fill out the survey. So it is active in the chat box. If you go there and fill that out, again, you're helping next year's conference as well as being able to receive your credits. Okay, with that being said, Tim, the next question is, can ICRC investigate a complaint against the Higher Education Institute?
Getting some good questions today. So that's, again, I guess I'll give you the attorney answer, it depends. And when I say it depends on the type of complaint we've received. So one of the enforcement areas that the agency oversees is public accommodations, access to public facilities. And, if we were to get a complaint regarding something along those lines as far as access to the facility, it's quite possible we would have authority to investigate that public accommodations complaint. Now, if you're talking about equal opportunity for education, that I'm a little less certain about, because to the best of my knowledge, we've never had a situation where an individual raised an equal opportunity for education in a higher ed situation. Is it possible that there's a scenario where that statute or that civil right could be triggered? There's so many hypotheticals out there. It's hard to say for sure. But to the best of my knowledge, that has not occurred, and I don't really have a certain answer about the education part of it.
Okay, thank you, Tim. The next question is, can harassment in an education setting result in discriminatory practices?
That's another really, really great question, and I think it's a timely question, because harassment, of course, can occur in the physical school building, but also, as we know, can occur in over the internet and online through various methods. And so dealing with that question of harassment, impacting your civil right to opportunity for education, I think we can look at federal case law and guidance, and where that determination has been made, and that it is possible to pursue a claim on that basis. There's it's a kind of a unique review where I might not recall all of it, but the individual would have to show that the harassment was persuasive, severe, objectively offensive, and in that, by being exposed to that, the individual was deprived of their educational opportunities, and that there's also an element that the administration is informed and it takes no action. And I mean, that's a very high level summary. It's again, this is not legal advice, so I'm just trying to provide general guidance. And I think that that analysis, that federal guidance that has offered, could be applied to a state matter, a state investigation dealing with equal opportunity for education. It's, to the best of my knowledge, we've not had a decision on that, but it is I think we could draw parallels to the federal laws and requirements and analysis, and make that claim could occur in Indiana.
Okay. Thank you, Tim. Got one more question, Tim. Who makes up the commission, and how are they selected?
So the commission is a 7-member commission, and it's created by statute. It can be found in Indiana Code 22-9-1, Chapter 1. And the agency, the ICRC, is executive branch agency, as are most agencies in the state. And our selection process, again by statute, those members are selected by the executive branch, and then they serve during I think it's a 4-year term. And during that time, they're responsible for reviewing, as I, kind of going back to the beginning of my presentation, they review the cases that we investigate, and they act as the ultimate authority for the agency, which means that they, by vote, will be responsible for that final decision, which will may result in the matter going into court for further judicial review. But it's all, it's all, going back to what I said at the beginning, we don't make the laws here, we enforce the laws. And those laws include how the agency is established, and how the members are selected.
Perfect. Thank you, Tim. Thank you for answering those questions, and thank you all for submitting those questions. I want to take a minute and thank everyone for attending Understanding Education, Civil Rights Issues Resulting from COVID-19. Again, thank you to the presenter, Tim. And please, again, at the end of this presentation, the survey will not be active. So please, again, complete the survey. Again, it'll be in the chat box. And one last thing I want to leave you, I know there were tons of questions and we couldn't get to them all. We do apologize. However, if you do need to get in touch with ICRC, you can reach us by phone at 317-232-2600. You can visit us on our website at www.in.gov/ICRC. And again, we are on social media, Twitter, Facebook, and Instagram. Our handle is at @INCivilRights. That's at @INCivilRights. These presentations are being recorded, so IBE does plan to send a link out so you can access it from their website and their YouTube for those who want these slides as well. So again, thank you everyone for attending. Thank you IBE for hosting, and Tim, thank you for presenting. Hope everyone have a good morning. Thank you.